I'm sorry about the interruption. My dog is not always well behaved when I lecture at home. All right, we were talking about not-for-profits having members instead of shareholders. The members then are the people that elect or select who's going to manage the business on a day-to-day basis. Now, there are times that some not-for-profits have, instead of individuals as shareholders, they may have a structure that says, for instance, that the that other entities are members. So example, you see this sometimes in local hospitals where there's a not-for-profit as a local hospital, that maybe it'll say that the local city council gets to pick one member for the board of directors, and that the local heart association gets to pick one member of the board of directors, and you can have structures that exist like that. And by the way, there's no prohibition against businesses owning stock in other businesses. It's not unheard of. Sometimes businesses, whether they be for-profit or not-for-profit, might find it useful to invest in other corporations. Again, understand that corporations can be remarkably small. They can have only one shareholder. Simply saying it's a corporation doesn't mean it's General Motors. It doesn't mean it's Pfizer. It can be, Craig Heckman Inc., or I can give it a really fancy name and there's still only Craig Heckman as the owner. Okay, just don't let the notion of it being a corporation fool you into thinking that means something in particular about size or complexity of the business. What it means is that if it's a for-profit corporation, that it has shareholders. And it means that if it's a for-profit corporation, that the shareholders are expecting at the end of the day to receive the profits in some way. Okay, that's how for-profit corporations work. If it's not for profit, expect that at the end of the day, the profits are going to be thrown back into the purpose of the corporation, and that purpose is not to make money for shareholders, but rather something like to enhance medical care in Cleveland, Ohio, or to promote research on heart disease. Examples of not-for-profits in the world of medicine, think of the American Red Cross is a good example. Think about the Cleveland Clinic is not-for-profit. There are plenty of not-for-profits in the world of medicine. In fact, most of the hospitals in the United States are not-for-profit. By far, the majority of hospitals in the United States are structured in a way that are not-for-profit. Again, that doesn't mean that they aren't going to send you a bill. That's not what it means. They would close their doors after about a day and a half if they didn't send bills out. You can't survive without doing that. Okay? It's a difference between charitable and not-for-profit. All right. Let's see here. In fact, I see from my notes here it says that in the United States, 47% of the hospitals are not-for-profit, 21% are for-profit, and 37% are owned by the government. So of those that are not owned by the government, it's about a 2-to-1 ratio of not-for-profits versus profits. So it's very common in the world of healthcare to see not-for-profits. All right, let's go to the next slide, which has, 2 palm trees. How nice. The exotics. And when we talk about the exotics, I've lumped them all together, LLCs, LLPs, PLCs, PSCs, PLCs. There's a whole series of initials, and increasingly you have a tendency to see these in ads, or you'll see a business that says so-and-so PSC or LLC. These are a relatively recent invention in the law. The invention of these exotics is all about providing a business with some of the advantages that corporations have and some of the advantages of partnerships, for instance, or of sole proprietorships. So let's take, for instance, LLC. LLC, wait a minute, before we talk about LLC, if you see Inc., INC, after the name of a business, that stands for incorporated. So that's a clue that they're incorporated. If you see Corp, that's for corporation. Sign once again that they're incorporated. It's the same. Inc. and Corp are meaning the same thing. When you see LLC, on the other hand, what you're talking about is a limited liability company. Limited liability companies, function internally much like a partnership, and that is there are people that have pooled their money for the purpose of engaging in a business. They're expecting to receive profits back out of the business, so it looks kind of like a partnership. Also looks kind of like a corporation, but what's going to happen with the liability? What's going to happen with the liability is in the name LLC, Limited Liability Corporation, or Limited Liability Company, pardon me. What we're going to say is we're going to limit the liability in the same way that liability is limited in corporations. And that is that if you're an investor in an LLC, we're going to protect you in exactly the same way that investors in a corporation are protected. So why do we even have them? Why not just have be a corporation or be a partnership, take your pick? Well, the answer is that there are some tax advantages of being an LLC. There are some tax advantages. There are some practical advantages, and that is in some states they still require a lot of formality with regard to corporations. And by formality, I mean things like annual meetings of the shareholders and things like that. With LLCs, you have a tendency to see the state laws be much looser and say you can operate kind of internally a little bit more like a partnership, a little loosey-goosey maybe, but we'll still give you the protection, we'll still give the investors the protections that we would give them if they were a corporation. So LLCs, pretty common, you see a lot of them. They still require that you get permission from the state to be an LLC because we're granting you that special privilege of protection from the creditors of the business. So you're still going to have to get permission of the state. Same is true with LLPs, PLCs, and PSCs. In each of those cases, you need to get the permission from the state. It is not something that arises organically. You don't say, let's just be an LLC. You go to the state and say, I want to be an LLC, here's all my paperwork, here are all the formalities I've met, I qualify, and then the state's going to, grant you the right to be an LLC. I've never known them to say no, but that's how it works. LLP is very similar, limited liability partnership. It's just different states use different initials, and there are some times that they'll allow you to structure it slightly different. There may be some states that allow both LLCs and LLPs, I don't know. PSCs and PLCs, professional liability company or professional service company. Once again, these are all functioning basically in the same way as LLCs. So when we get down to PSCs as an example, originally there were some ethical prohibitions in some of the professions against operating as a corporation. So as an example, in Ohio, it was unethical for lawyers to limit their professional liability. If you're a lawyer, you have unlimited liability to your clients. Okay, that's just that's part of the baked into the ethics of being a lawyer. And as a result, if you're in a partnership in a law firm, you have that personal unlimited liability for the debts of your partnership. And you were not allowed to incorporate to avoid that type of liability. Well, there were at one point some tax advantages of being a partnership that made lawyers say, can't we be partners? Can't we? We're still willing to have that unlimited personal liability. We're not trying to dodge the liability issue that the ethics require us to have unlimited personal liability for our acts as lawyers. But can't we get the advantages of being a partnership? So ultimately, states like Ohio said, okay, we'll let you do that, but you can't be an LLC because that would give you, that wall between the creditors and the shareholders. So we'll let you be a special type of corporation. And again, depends on the state what set of initials we use. But for some professional businesses, they might be in Kentucky, for instance, we use PSC. And so the notion is, well, you're going to have that protection against the claims of consensual creditors, okay? And that is, you might be able to stiff the guy that sold you a copying machine. You might be able to stiff the bank that lent you money, but you can't stiff the person that you owe professional services to. That's a different sort of category. And so that's why we have some of these different initials. I wouldn't be too worried about them. I just want you to be familiar with the idea that these kinds of things are out there and exist, and they basically function as sort of a hybrid of partnerships and corporations, designed to shield designed to shield to some extent the owner investors from debts of the business, designed to function internally a little bit like a partnership, but they come with different bells and whistles in different states, and there's no reason for you to learn all of it, and I'm certainly not going to test you on understanding the difference between a PSC and an LLC, or what's a PSC in Kentucky versus what's an LLC in Ohio. Don't worry about that. Just understand that when you see those initials, you're usually looking at something like that. Again, LLCs, though, I will mention that LLCs are far more common than the others. We're even seeing some really big businesses occasionally structure themselves as LLCs. And I am not sure why, to tell you the truth. I'm not really sure. But for instance, Chrysler, which went through some very difficult times and reorganized many years ago. When they reorganized, they came back as an LLC, and I'm not quite sure why, to tell you the truth. I'm sure there's some exotic tax reason for it, but LLCs, LLPs, PLCs, PSCs, they're all there as sort of exotics. Again, rules vary state to state. Don't worry too much about that. Last slide says just what I just said, the rules vary state to state. What I think I want you to really take home and think about with regard to business organizations is that it does matter what your organization is. There's an enormous difference between your potential liability as a partner and your potential liability as a shareholder in a corporation. There's the ability to get yourself in deep trouble with partnerships by virtue of simply waking up and saying, oh my gosh, the way I've been doing business has allowed the law to consider me a partnership, even though maybe I never really thought of myself as being in a partnership. There are advantages and disadvantages of each. I have owned shares of stock. I have been a partner in partnerships. I am currently a owner, 50% owner of an LLC. There's benefits and risks associated with each. The whole point of this chapter is to give you some familiarity with those. Certainly, as always, if you have questions, let me know. Thanks for hanging in there. That's it.